With that, we'll go ahead and get started. Judge Gunther joined us, but all I see is her pooch. So if she comes back, she can introduce herself. Today, our discussion is going to be about the role of the court in AOT. And, you know, there's a real spectrum. So we chose two judges, one judge, one magistrate, to talk about how they do their check-ins. And we're going to start with Judge D'Antonio from Georgia. And he's going to talk for about 5 minutes and then pass it off to Magistrate Kitzler.
Okay, well, I'm glad I looked at my email last night, Brooke, where I said I would be happy to do this. Again, my name is Mark D'Antonio. I'm the Muskogee County probate judge, and we are probably the only probate court in Georgia that has been doing outpatient and voluntary treatment orders for over a decade. We have a state hospital, a crisis stabilization unit, and 2 outpatient providers in Columbus, Georgia. So that's part of the reason why I'm doing that. In terms of what I'm being asked to speak with, I'm also, by the way, subject to the respondent individual's objections. All of you are welcome to watch my hearings. They are hybrid hearings or by Zoom, and I do welcome the input and constructive criticism. I let Amy, Brooke, and Betsy watch some that actually weren't even AOT cases. But they did have an opportunity to watch something that we call formal status reviews. And our formal status review, and to be honest with you, I've been making this stuff up as I go for, as I said, over a decade now, and it has evolved. But our formal status reviews are really probably the most formal thing we're going to do when an individual might need to be reminded that he is or she is under, in fact, a court order, and that they really do need to keep their appointments with the doctor or not elope from the group home, or many of the other things that I specifically put in my court orders. And so that's what these formal hearings are about. There can be consequences for violating the court order. So I feel it's real important that we do have a lot of due process and formality related to that. There is a notice of the hearing. The individual might be served by the provider or just told you we got a court date. I'm not making the sheriff serve them every time or anything like that. But we have, although if a person doesn't show up for a court hearing, I will actually direct the sheriff to sometimes bring folks. It really depends. And I know I'm probably, y'all can tell me that that's wrong later. But we do have, at those hearings, I do afford the individual an opportunity to meet with his lawyer, and their lawyer usually will go over what we're really about, and they'll talk with it. And that's, I think, a real important part of the process there, is because that attorney can explain, well, you know, you might not have remembered the court order as much when you were getting out of the hospital because you were not doing as well as you're doing now, but these are the things that they're concerned about, and that attorney will spend as much time as necessary to listen to the individual so that their concerns can also be addressed. And then the other folks that are usually there is, the provider, and usually there is, and depending on what they're asking me to do and what's going on with that, they might bring 2 providers, one to be good, or 2 different people from the same provider, one to be good cop and one to be bad cop. Or sometimes there's a situation where you don't really want to jeopardize the clinical relationship that the person has with one of the providers. So a different person might be the one that says yes, and he's missed 15 appointments or whatever the case may be. I insist that both the outpatient provider and the individual be represented by lawyers, especially if they're asking me to perhaps order the person to be apprehended as a non-compliant individual for up to 48 hours in a hospital. 90% of the time, I'm not doing that. 90% of the time, it's more of I'm answering, I'm reminding them of of why it's important to stick with the court order. I'm trying to focus on positive things, but it is in a formal situation where the attorney for the petitioner has his clients give direct evidence. The respondent individual's attorney can cross-examine. Then I will hear everything that they want to put on from the respondent's point of view. Other players that are often there, I think it's real important especially if we have issues related to our state agency is the Georgia Department of Behavioral Health and Developmental Disabilities. Our outpatient providers are community service boards that receive funding from DBHDD, but are individual entities. Sometimes some of the issues that can be about, oh, that's not our job, having a representative from DBHDD there as another person that could be called as a witness, but is also an interested person in terms of it, is sometimes helpful too. Did I kill my 5 minutes?
Yeah, so just to make sure I understood. So it's a formal court hearing. You have
a motion for status review is usually filed by the provider. Although I will also do them where it's requested by the patient.
And you are dressed in your robe, you sit at your bench, it's in your courtroom, and you hear both sides. You start with the prosecutor or the petitioner, and then go to the participant, correct?
Right. Yeah,
Okay.
I mean, technically it's whoever the moving party is. So if it was the petitioner, if it was the individual under the outpatient treatment order moving as the moving party, technically they would go first. And
Okay.
sometimes we break it down into more informal, but the ones you got to see were fairly formal.
All right. And I'm sorry, you may have seen in the chat, I skipped those who were had their cameras off. So Judge Gunther, do you want to introduce yourself? What about Judge Sigler?
Hi, I'm a magistrate in the Stark County Probate Court in Ohio.
Excellent, thank you. Judge Kavanaugh.
I'm sorry, my Zoom is not working very well today. So I'm Magistrate Tiffany Kavanaugh. I work on the AOT program in Seneca County, Ohio.
Yes, thank you. And Joanne, not a judge.
Hi, everybody. I am on the development team for the Treatment Advocacy Center, and I'm trying to absorb as much knowledge and insight as you all can provide. Thank you.
All right, Magistrate Kitzler.
Yeah, although Amy, one other thing that I did want to point out is the formality is something that at least at one point we thought was a good idea because it helped distinguish me from the rest of the treatment team.
That makes
And-
sense. And
Go ahead.
we have we've seen courts bridge the spectrum of formality to informal. So there's no wrong way that we can tell. Magistrate Kitzler.
All right, so I guess we do a less formal version of, we don't even call it anything in particular, but I suppose you would call it a check-in. And the deal is that as soon as these people get out of the hospital, they have to come see us. And they start out seeing us weekly. And it's at least when they see me, the judge and I switch off. She'll see them one week, I see them the next week. She pretty much does what I do, I think, but a little bit more formal. We have found out that a lot of our people have been through other specialty courts and didn't do very well, like Veterans Court and Mental Health Court that our local municipal court has, or drug court. And so we try to be a kinder, gentler version of what they think this kind of court ought to be. They appear with their case manager and an AOT coordinator. I don't wear a robe when I do this. I did in the beginning, and I decided to kind of keep it informal after a few months when I started taking over this project. And you know, we mostly chat. I have a report in front of me that the treatment provider gives us every week, or sometimes if they're on a less frequent schedule. So all the participants know I've got something in writing in front of me that says what they've been doing. And sometimes, you know, they know when they come in, I'm going to ask about something that's negative. But I try to keep it fairly neutral. And you learn a lot about these people from just talking to them. And you can tell whether they're doing well, or are they manic this week? And if they are, then you can ask probing questions about why this is happening. I just don't want to have people come in and just be quizzing them every week. Are you taking your meds? And did you do this? And did you keep your appointments? We work that into the discussion, but I just try to get to know them and get them talking. And you find out a lot about how they're doing by what they talk about and how they talk about it. So it's not a situation where I have a script. And you know, I'll try to find out if there's something going on, you know, positive or negative. And if it's a negative thing, I try to direct them to something or someone that can help them. And if it's positive, I try to give them reinforcement. But sometimes we just talk, you know, and you find out a lot about what's going on with people when there's just some sit down chat. So and then I ask the mental health people who accompany them to give me some idea what they think I need to know about, or do they want to add to the encouragement, or do they want to chastise them about something and say, oh, you know, you were supposed to keep your appointment with me yesterday, and they can't just feed them a line of BS when I'm sitting there listening to it. They have to make it sound a little better. But you know, it's sort of a different procedure depending on who I'm dealing with. And sometimes we just talk about anything in the world, you know, whatever's on their mind. Sometimes it's the weather, sometimes it's what they did over the weekend. If they're excited about something that's coming up, if they have a court case coming up in another court, sometimes they vent about that. But I just try to keep it kind of loose and informal, and I learn a lot about them by doing it that way. We give them less and less frequency in terms of check-ins based on how well they're doing. If they're making progress, after a few weeks of coming weekly, then we'll stretch it out to every 2 weeks with the consent of the mental health people. And probably everybody has to come at least once a month, but anywhere from once a week to once a month, depending on how stable they are. We really don't have people that don't show up, but once in a while they do. And then we do a pickup order and send the sheriff out to get them. But that's a rarity. But sometimes we have to do that to remind them that despite the informality, this is the court and they're still subject to our order. Thanks.
That's interesting. So no attorneys present.
Nope.
Okay.
don't need them, and we can't afford them because they're all court appointed. So we kind of made that decision early on, mostly for financial reasons, but they would serve no purpose in this setting, really. They would just be extraneous. We don't need them.
So now we'll open the floor to others to share what they have, and we want a discussion, ask questions of each other.
I do have a question of Judge Kitz or Magistrate Kitzler. How big is your docket? How many cases do y'all have?
We're a very small county and a small court. During a week, we've probably had as many as 14 or 15, but we usually have less as we change the rotation. So we may have a total of 15 people that are subject to our ongoing order, but maybe today I only see 6 or 7 of them. Our goal is to try to devote one morning a week to AOT. And so far we've been able to do that. And we always said we're going to have to rethink it if we get more people, but we're in our 6th year and it's been a pretty steady number. We've never had more than about 16 people at one time on our AOT docket. So small court, small county.
Yeah, Magistrate Kitzler, this is Judge Fish from Porter County, Indiana. We're doing things very similar to how you were doing things. So it's great to hear that I feel like I'm on, a good guide path. But I'm curious, you do it every week. I don't really have time on my docket to do it every week. And I think my docket size may be half of yours. You just make the time, right? You're just devoting the time on the calendar.
We're probate court, so we're not heavy in the courtroom most of the time anyway.
Okay.
So it's been manageable.
And then I'm curious, I had a thing recently where a couple of the clients were very talkative. I couldn't get them, out of the room fast enough. Do you have any tips or pointers for what happens when they want to stay on topics or loop into topics about how you can get them out of there without making it feel rude?
Not really.
Okay.
You just do the best you can. You learn little tricks. And they know that they've got a 15-minute time slot. That's it. So,
Okay.
They kind of know that. And sometimes you just say, I'm sorry, we got to wrap this up, but we'll continue this conversation next time. And
I think it's maybe important for me to set that. Yeah, sorry. I think it's important for me to maybe set that 15-minute boundary up front a little clearer, or make sure our case managers are doing that.
Yeah. And I'm not saying it's a real strict timeline, but everybody has that concept that this is your 15 minutes and I'm willing to spend the 15 minutes. Sometimes they're in and out. We don't have a lot of chemistry going today, and that's all right. But I'd say for the most part, we use the 15 minutes for almost everybody.
Thank you.
Mm-hmm.
Judge Fish, I just wanted to follow up real quickly, let you know we did a satisfaction survey, piloted it actually in Ohio, and I think Judge Kitzler's court was represented on there. But one of the pieces of feedback, for the most part, it was all very positive. That was a positive experience, but we did ask what they liked least about AOT, and one of them was that it was a big commitment out of their schedule, particularly if they had jobs, so I think that, being respectful of the next person, that's waiting to see you, we got to kind of keep things moving because they've got, places to be. And so I thought that might be helpful.
Yeah, thank you for that, Betsy.
One of the things we're considering is not just always doing it, like our time is Monday morning. I mean, what a god awful time for everybody, right? So we've been discussing, maybe we want to try an afternoon once in a while, and maybe go midweek when people's lives are a little better than they are on Monday morning. But we haven't decided to change anything yet, but we're talking about it.
Yeah, I'm doing high-level felonies on Monday morning, so everybody's already miserable to begin with, right? Not a problem.
I get that.
I had a question. Do you have all the participants in your courtroom at the same time, or do you call one person in at a time?
In our court, they come one at a time. We visited other courts before we started our program. And of course, larger counties with more people have to do things a little different. We saw Summit County, Judge Stormer there. She has a way different setup than we do. She has everybody in there, but they come up to the bench one at a time. And so that's another way to do it. But we have the luxury of being able to give everybody their own space and their own time. I realize that's not the case for a lot of courts.
And
Judge Antonio, do you do the same, or?
Yeah, I mean, it's the way I look at it is it's not the other individual's business about what's going on. So no, it's one case at a time, one set of individuals at a time. And plus, I think that's important to make them understand that I'm concerned about them, not the next person there or anything along those lines.
I do have to say for Judge Stormer, she does put the graduates first when we went and visited her court. So part of that is she can let people see that they get through the program. But our courtrooms, we're working on our AOT program and they're just not equipped to hold that many people, and just we had too many safety concerns. I will say that Judge Stormer is the only the only court that does that we're aware of. And she is a former drug court judge, which is the model that she built her court on.
If I could jump in for a second, our system in Louisiana is statutorily driven. What we can do and when we can do it is pretty much outlined in the statute. I can tell you that attorneys are very necessary in our system, even though our system has no teeth to it. There's no penalties. There's no contempt. It says specifically we can't even fine the participant in contempt. But if a court has the authority to compel their attendance by the sheriff picking them up, I think there might be problems in not having lawyers in the courtroom. One of the oddities, one of the different things that we have is the petitioner, the one who files the petition into court to have this person, the respondent, admitted to AOT, doesn't even participate after the person is admitted. Once they are admitted to AOT, it's between the court and the participant. And every participant has an attorney from the Mental Health Advocacy Center that we have here representing them for all aspects. They have to be at all court appearances. And our court appearances are similar to the magistrates in the sense that we never have more than 4, 5, 6, 7 participants. And some of them are formal, meaning you have to have the court reporter because there's a motion to amend the treatment plan, where there's a drastic change in the treatment plan, and we have to discuss it and see if that becomes an order of the court, or if they're up for renewal, because our statute only allows 12 months and then 6-month renewals after that. And before each renewal, and of course the original admission, they have to have a treating physician's report within 10 days of the from an examination, within 10 days of the hearing. So one of the problems we have is there's no teeth to it at all. We can't have them picked up. We can encourage them. We have a case manager who contacts our participants every week, sometimes twice a week. And people usually get in every 3 or 4 weeks. They'll come in. And again, it's the sit down talk. How you doing? You're taking your meds. What can we do to help you today? What can we do to help you with your life? Are you having trouble with your phone? Do you have your voicemail set up? Because you can't make your appointments if you don't know how to work your phone. And our statute, like I said, is a little different because it has no teeth to it. But I think it's important to get them in, and our law requires that the lawyers be in court with the participant. I just wanted to add that. Thank you.
Yeah, actually, I'm not aware of any AOT courts that use contempt. And I think most would say that theirs are just like yours and don't have teeth necessarily. So I think that's more the rule than the exception.
Yeah, we can't even pick them up. We can't order the sheriff to pick them up. Yeah. Now, our crisis intervention team from the sheriff's office will provide transportation, but we can't, if they don't want to get in the car, that's fine.
And that's true of a lot of places too, unless they're in a psychiatric crisis.
Well,
If they're in crisis, then it's a different story, but
the custody
yeah,
order,
that's pretty
48-hour
common.
order. Yeah.
Yeah, it's pretty common.
That's why we pick them up, because we want to make sure they're not in crisis, because we always figure, why would they not come to see us? They must be in crisis. So we get proactive when they miss a court session, unless we know something specific's going on, like if their case manager comes and says, so-and-so is not going to be here today, this is what's going on. You think you could give them a pass, and we will. But if there's no reason and we're concerned about their safety or whatever, we've got plenty of ability to pick them up, and the law would support us.
Well, and I guess my formal status reviews are as close to contempt as one gets. So that's sort of, although I really do think that there's a benefit for, if I know I'm not going to be issuing an order or doing anything to modify the plan, I think that there's no reason why we can't do the informal check-ins either. In fact, actually, I kind of like the idea of something. Well, I mean, I think it's really important. The more I learn about this, the more it's important to build a rapport with the individuals, and the informal check-ins might be a better way of building that rapport. And then if they see me wearing the robe and all, oh, this is serious. But I don't know. As I said, I
mix it up.
So
Try a combination.
I actually want to, so we're building our program here in Montgomery County in Ohio, and we're actually trying to set it up with kind of the two processes where we want to do the informal for most of it. Well, first meeting in the robe, but we want to go informal from that unless there's a concern that's filed by the outpatient provider. So we have a form that we've created where it's the concern that they're decompensating or they're not doing something they're supposed to. And we created that form so they could ask it. So then we could do the formal hearing. So it's the bringing out the black robe would then be what we were trying for. Does that make sense to people? That was sort of what we were going for, is informality unless there's a serious issue. And then we'll have the robe and the attorneys present.
Well, I try to have at least one little status hearing within a month of somebody being discharged from inpatient. To be honest with you, that's just as much to make sure that, and one thing is we are not fully staffed the way we ideally should be for an AOT program. So that's also to make sure that the provider has been doing what they're supposed to do. And I do that one as it's not a formal with a motion, but I will set a status hearing of when within 30 days of discharge or something. And it's really almost, those are more, one, the person might have a better way of understanding the order that 30 days out, but it's really half the time is, okay, well, I get colloquial with this. Okay, well, the hospital has now dumped it on you and you all didn't want to take this individual. You're ordered to provide services for them. Tell me what you've done to help with their individualized treatment plan, so to speak. So I use that, at least the initial one, to sort of hold the provider accountable, make sure we're on board both sides. And then I could really see transitioning to something much more informal.
That's 50% of our job, I think, is we're there to make sure the mental health people are doing their jobs as much as we are to have the patient do their job in treatment. You know, it takes both, and that's why we're there.
Absolutely. And Magistrate Doggett, I think that's a very interesting approach. And I can't wait to hear how that goes. I don't know of another court that works that way. I know Summit County does their renewals in a separate hearing than what Judge Stormer does, but this will be the first time that I've heard.
We are definitely trying to come together with a program that's going to work for our county, but we're still trying to get there. So,
well, we can't wait to see the good things happen.
If any county has done their due diligence, it's Montgomery County, Ohio.
we're trying.
Judge Tats, I'm sorry. We've never had anybody from Arizona, and I would love to hear how things work in Arizona.
Sure, I may not be the best one. I'm much more of a taker than a giver in this seminar. I'm vice chair of a task force that they put together, Arizona Supreme Court last year. We're looking at trying to do something different with our mental health evaluation and competencies for criminal cases when it comes to misdemeanors. It's just, it just doesn't work what we've been doing forever and ever. And on the task force, the thing that we keep coming up with is some form of AOT, doing something where we're working with clinics and case managers, everything you all are talking about. And obviously I can hear from this is all mostly probate. And of course we have that in Arizona. We have, it's not in the municipal court where I work, where we just deal strictly with misdemeanors and criminal, but we do have a system where if someone is determined to be, I don't even know the terms because I don't practice in it, but danger to self, danger to others, acutely disabled, similar to what you all are talking about, they see the judge, they have the court order treatment, they have to do things, and we deal with them tangentially, but I'm here just to kind of, because I'm having a hard time. We've been named a pilot court to try and do this, and we have mental health courts here in misdemeanors where we do similar to just having the providers give us reports and work with the people and give them things they need to do. It's a diversionary program where if they successfully complete everything, the case ends up getting dismissed. But we're trying to get out of, when it's a little bit farther down the road, when the person may not be competent to stay on trial, rather than finding them incompetent, paying for restoration, or finding them incompetent and just dismissing the case, getting them into some sort of treatment program. So again, I may not be the best one to talk about what we're doing in the probate courts because I've never practiced in them, but we're trying to use AOT for kind of a different purpose than what it sounds like some other people are right now.
And isn't Miami doing something with misdemeanor AOT? And I'm working very closely with our solicitor who does our misdemeanor prosecutions and our DA to identify, and I want to start this slowly, and there's a lot of statutorily, there can be some challenges about this, but we're talking about trying to identify what some of the prosecutors refer to as familiar faces. As, hey, this person, we know that they're, let's see if we, as I said, I actually did something yesterday with the recorder's court, which is a first appearance court, where it was diverted back to New Horizons and to me to get them stabilized. And then, so we're playing around with trying to do criminal referrals to a civil, my civil commitments. I'm taking that extremely slowly because as soon as I get one of these cases to backfire, everyone's going to say, see, this didn't work. I don't know if y'all have had other experiences with that.
We're doing so with SB2 in Ohio. That's basically where we have the transfer of the cases from criminal over to civil. Right now, we're only doing it for individuals who have been found incompetent and unrestorable in time. So, but amazingly, our prosecutors have been kind of on board with it and it's municipal court. We're not dealing with any of the common pleas here, but our municipal courts, the prosecutors were on board because at least gave them something to say they've done with the case. So we've actually had some pretty good luck of them sending the cases over to us, and then we can get the individual into treatment. That's part of the reason we're working on building AOT, is because we want to actually be able to follow the individuals better. But they've actually been pretty good about the shift over, because to them, they can tell a victim, look, they're now getting treatment. So they've got something to say. And then we're happy because we're getting them out of the criminal system.
Well, and I'm actually, I think I got this from the last judge chat. I'm insisting on a no pros. If you want to send somebody over to AOT, I'm not going to be there to restore somebody to be then prosecuted.
Yeah.
Right. I can say that at the last chat, I mentioned we were working on that in Reno, Nevada with the competency court. And actually, since the last chat, I've had at least 2 to 3 participants that have come in that were waiting for competency evaluations, and the DA agreed to dismiss their charges and send them to AOT. So I can say that we've also had prosecutors that have been friendly to this concept, because these are usually people who have already been found incompetent several times over, and they're back in custody. And because our competency is kind of first in line versus the nature of the charge, right? So when we get rid of the lower level crimes, then the felonies, those cases move up the competency line, and we've actually been reducing the backlog now. Obviously, we have a numbers issue of only about a maximum of 50 people we can take in our AOT program. So we're also trying to utilize the mental health court, other resources we already have to divert, dismiss, do more so with this competency list. So I have to say we already started that movement in Reno, and it's great to see. And this is post a visit to Judge Leifman's court in Miami. But we have our defenders involved, the DA involved. So it's quite an exciting time right now because we're doing it. So I was happy to report that back to the group today. So.
Other thoughts on how you're running your court, or what works, or if you've tried something that doesn't work? We'd love to hear about that.
A couple of quick comments. I agree with Judge D'Antonio. It's got to be completely separated from the criminal justice system. Ours is a pure civil proceeding. I'm sure yours is too. But if a DA says, "Hey, I've got somebody that looks perfect for your court," I say dismiss the case. Dismiss the case and send them over. We'll be glad, or we'll do an evaluation of them before, and we'll tell you if it looks like they're acceptable. We have very strict and very specific criteria for being admitted as a participant. The other thing that I wanted to mention was we're talking about this contact with the participants, and I'm sure all of you would agree that there's no cookie cutter, there's no one size fits all for these folks. In the extreme case, here, they're admitted to AOT. They might try for a week or two, and then they shut down because people are calling them. They say, "Oh, you got this doctor's appointment. Oh, we've got a med check. Oh, can we help you with your Social Security? What's your and they just shut down. And it takes building up confidence with that person. Sometimes, most of the time, we go through our case manager who says, "Hey, can I talk to you for a minute?" And then after some trust is built, the case manager can go to their home, and then maybe, "Hey, the judge would like to talk to you." And if the case manager can go, we'll do a Zoom call where we can see each other. And then I'll call them individually once or twice. "Hey, how you doing? Everything going okay?" Till finally they're willing to come back to court. And it might take 2 months to build that trust up. But then finally they come back, and almost invariably by the time they come back, they're back invested in the program. So with the harder participants, it's a multi-step process that you just have to keep after them and keep building that trust.
One thing, we don't have a renewal process. So if they want to re-up a petition, then we're going through the entire process again, from a new evaluation, a new certificate, And I also insist on the doctor or whoever is my expert for that purpose to actually testify about why this person meets criteria in those initial hearings. I don't know if that's what you all do or not. But.
Yeah, it's a similar, they can submit a report, but they must be available either by video or in person to testify. If there's any questions concerning their report or considering their treatment recommendations by either side, by the mental health advocate or by the petitioner's attorney, they have to be available for questioning under oath.
That makes sense.
Well,
I guess that's the other thing is you can consent to AOT without a hearing. I think that defeats the purpose, at least initially. Because I want them to know what what you're agreeing to. And yes, I'm Mark, or I'm the judge. But I want them to understand what they're getting into, as opposed to them consenting to something that they might do just to avoid going to court. Or whatever that's worth.
so that's interesting. I am curious how you all do your continuations, or if you do continuations.
Our initial order is good for 90 days. And that's too short a time to make a lot of progress with most of the people we see. So we have a statutory procedure for continuing the outpatient treatment. And it's all part of what we call the civil commitment proceedings. But it depends on the mental health people requesting it. Sometimes we don't agree. Sometimes they think they're done and we don't think they are. That's kind of a difficult situation. But most of the time we're on the same page. Most of our people really need about a year before they get stable from our perspective. But we've had some people that did it longer, but we'll continue them for a year. After the 90 days, we have a hearing. Most of our people agree that they need to stay in AOT, so it's really not a big deal. Once in a while, we have to have a full hearing, and it gets a little contentious, but not very often. And then we continue them for another year, but our statute's open-ended. We can keep them forever if we can justify it. Of course, we would never do that, but there's no finite time period that the law allows us to work with them. So, but I'd say a year, maybe 18 months for some people. It just depends. And a lot of people make a good amount of progress in a year's time. But we have to have a hearing to continue them after the 90 days.
Yeah, I know we do our statutes every 6 months. So we have the full, we call it a repetition. So they repetition the program, they have the evaluation, they present the treatment plan. But the difference is I usually get a status report from the AOT program on how they've done, because we track if they've been hospitalized, if they've been arrested, things like that, to kind of maintain our statistics in that regard. So we have full-on repetition hearings every 6 months.
Magistrate Heather, I know you guys are struggling up in your county to get your program up and running. And if I recall, it's kind of the mental health systems are dragging their feet. I wonder if maybe some of your peers here have some suggestions, but I'm not sure I understand what the holdup is.
I think the big thing is there has always been basically one provider in our county who has done 90% of anybody in need of mental health services. our board in turn has kind of deferred everything to them. It almost seems more like our local county board gets its dictate from that one provider versus them saying, hey, these are the services we need you to be able to provide. I think we finally got it through our local boards are finally understanding that, because we have now started inviting other providers to meetings. We have been, as a court, going out and just educating providers and telling them how they could file in our court, for the people they're trying to serve. And just, I mean, and really, when I say recently, I'm talking like within the last maybe 30, 45 days, we had our first meeting with the local county board and multiple providers. So I guess as a collective group here, I'm wondering if anybody can offer some advice as to some of those initial hurdles. I guess the providers are not quite sure how to use this service. I have been using some of the data you provided me, Betsy, about how, this can work for the right people and it's been shown effective. But our providers are still not quite sure practically, the day-to-day stuff. How would they tell their staff how to use this tool that of using the civil commitment assisted outpatient tool of the probate court? So if anybody has any great talking points or what sold your providers on the usefulness of this program, I'm all ears.
We have more success with the provider who has case management services. Our people need that. There are a lot of providers that will just do counseling, and maybe they have a psychiatrist that consults or whatever, but many of our seriously mentally ill people need case management. So I think that's a key thing.
I actually found some of our providers have to be sold on AOT. That to me, I was surprised by that, but there's a lot of people that are like, no, you can't force anyone to, and I'm like, that's not really what we're trying to do here. But that actually can be challenging. There's some providers that have remember the bad old days or something along those lines.
Yes.
That have that buried in their head, and it really that's part of my, well, come and watch me. Just to try to get them to open up about that kind of thing. And actually playing one provider off of another for the turf war thing sometimes can help.
Okay.
But the idea, but basically there are some notions about how this is the worst thing in the whole world. In fact, that might have even been the notions of some of the powers that be with our state Department of Behavioral Health at one point or another. So really having to build that rapport, let them know that no, you're not authoritarian, just ordering everyone be held down. I think that can be very challenging, and there might be some individuals at that provider that's been doing it forever, that have been there forever, and they're not going to change, and that'll be a real challenge for you.
Thank you.
And TAC offer any peer-to-peer Zoom similar, what you're offering the judges and magistrates here? I wonder.
We do. We have a clinicians group, we have a champions group, and then we have what's our last one? I'm drawing a blank.
Monitors.
Oh, AOT monitors. But the problem is getting, the folks that have those issues aren't the ones that show up. We have a way to compel them to at least listen. But that's the struggle.
So what I find interesting about your situation in Portage County is that the provider is actually doing this in other counties.
We know.
I mean, so it doesn't make any sense. And their executive director got her clinical skills in a county in Summit County, where they use it and have been using it for 25 years.
Right. Yeah.
I don't know.
But if you
Sorry,
can't-
just shaking my head.
But if you can't get people to file petitions, the program's not, I mean, that, we have 5 AOT programs, pilot programs in Georgia. Actually, they didn't want me to have one, really, even if I had been doing it for a while. And that's probably, there's 2 pilot projects that do not have really anyone in their project because the provider hasn't gone ahead and filed those petitions.
Oh.
So
No, literally,
So
they
you're not
filed,
alone.
they filed, the agency, who shall remain nameless, filed one today in the court and left half of this, like, didn't fill it out all the way, left pieces off. I'm like, this is
Well,
the same
the
thing
first
file
time
in
I
every
sat with a
other county.
caseworker and
Yeah.
said, it's a form, but we need to fill it all in, and
Yeah. Talked to one of the people who run their local group home. They didn't even know this was available. And we're like, well, we talked to she's like, oh no, he's my direct supervisor. I wish I would have known, because she uses it in a neighboring county, because she manages a few of their group homes. Just, and for 2 years we've been going, how do we get this going with you? What are your processes so we can work with you? Down to what day of the week would be good to have the docket. We will schedule around you. You want night court? We'll come at night. Wow. Yeah. It's
Legal ways you can compel them to participate. Like,
the judge has resorted to some public shaming that's getting around it. I think that's why we're finally getting some tracking, leveraging some of that other stuff of pitting agencies against each other. The judge came in 2 years ago. She was trying to play nice in the sandbox with, all the community partners. After 2 years, some people are not going to be played with as nicely now.
Well, it's 3 o'clock here in Minnesota. Anybody have any last words? And
One takeaway from this is that there's just not one size fits all. You can have whatever program works with your circumstances, and, keep tweaking it, keep trying things, and, be open to new ideas, but feel confident that if you feel comfortable doing what you're doing and your people are getting better, you're doing it right. Even though it may not be how everybody else in this forum is doing it, you have to have confidence in what your skills are and what your community has and what your population needs. And just keep doing the best you can and tweak it as you need to.
I agree with that.
Well said.
well, thank you. And we will see everybody in 5 months, because August we take vacation and there are no AOTLN activities. So your round will come up in 5 months. And never hesitate to reach out to us if you would like. AOT@treatmentadvocacycenter.org. And it's great to see all of you again. Thank you.